We have a lot to cover today. In this webinar, Shakeup at the NLRB, what employers can expect under Trump's second administration, should be a lively discussion. My name is Michael Volpe. I'm the former chair and a longtime partner in Venables Labor and Employment Practice, which is national in scope. Today, we are joined by colleagues from across the country. We have Beth Ann Lennon, out west from our Denver office, Carl Mazinak, south of me in Washington, D.C., Allison Gottfried, who's also resident in the New York City office, as am I, and Taylor Bleestein, who's from our LA office. What we're going to do is jump right into this topic. There's been a lot going on in President Trump's second administration over the last few days. And I'm going to turn the floor over to Beth Ann, who's going to walk through the initial comments respecting this topic.
Hi, everybody. Thank you so much for joining us. I have the easy part of this because this is stuff that I think everybody knew was coming and is expecting because it happens every time there's a change in administration. So that is the change in leadership that we are going to be seeing, and we are already starting to see over at the board. So we can fully expect, although it has not quite happened yet, that the current general counsel, who was appointed for a 4-year term, will not continue to be general counsel for much longer. Best case scenario, that 4-year term is up at the end, or in July, excuse me, but we fully expect that there may be a termination much quicker than that. In fact, it could have happened on day one, though it didn't. This is obviously going to be notable, and we'll do a deeper dive into these details as I hand this over to the next person. But the current general counsel, Abruzzo, is actually one of the most aggressive in relation to taking that position and making new law with it. So there's lots to overturn here. There's lots of changes that will just be made by the shift from one general counsel to another. And then another one that isn't that surprising is obviously the change in the chair. So the prior chair, Lauren McFerrin, was not the chair actually when Trump took office earlier this week, but she had been, and there was a push to try and get a second term and continue her in that position. Not surprising at all. That was not successful. And so currently, day one of the administration, a new chair of the board was appointed, and that is Marvin Kaplan, the only Republican sitting on the board right now. Can we go to the next slide? So looking at what is going to change into what is coming, right? Like we know who's going out, now what's coming in. So there are currently 2 open slots on the board, and when somebody is appointed to the board, that is going to be for a 5-year term. Right now, we have 2 Democrats and 1 Republican sitting on the board, and we fully expect, not surprising again at all, that those 2 open spots will be filled by President Trump with Republican members. And so we'll have a Republican majority. Again, not that uncommon when there's a change in administration for this kind of a shift to occur. It's just an opportunity here for it to occur very quickly. And I also will note that there are going to be those 2 Democrats currently sitting on the board will have their terms end during the current Trump administration. And again, as we see the old general counsel step out, we're going to have a new general counsel appointed. And I do anticipate that the first thing we'll see from that new general counsel is reversal of a number of those memos, again, that we'll go into in more detail as we dive into the presentation that the current general counsel issued during her tenure. Let's go to the next slide. But I will highlight changes in authority. It may or may not have the same impact that it usually does. We are in a unique moment for a number of reasons, and that includes the fact that there has been constitutional challenges to the authority of the NLRB and the way it is operated by several big companies within the United States. And it is notable that some of those companies are strong supporters or run by strong supporters of the current president. So we anticipate the courts will continue to play with this question, and it may have some implications, though. If I were a betting person right now, I would say the board is going to continue to exist, and the form and what it does is going to look very similar, but we will see more shifts in relation to its agenda. On a similar note, a question in relation to just how much the board will be doing relates to the aggressive efforts to cut the federal budget that we're seeing from this administration. And we do expect that the budget for the NLRB will not be spared from those efforts. So whatever they are going to be doing, and again, we'll dive more into that as we go, we expect they're going to have to do it with less money. So exactly what those numbers are haven't been fully formulated, but we do expect there will be less for them to work with. And one novel thought that we wanted to raise here is, as I mentioned before, there are 2 openings on the board right now, but there is an open question about whether he would want to, President Trump, would want to make appointments to those positions at all. So right now, you have to have 3 members, according to the United States Supreme Court, to lawfully act as an agency. So there is an opportunity here to potentially undermine the ability of the board to make any decisions whatsoever if he were to elect not to fill those positions and to not fill future vacancies as they open up. However, again, if I were a betting person, I would say that's probably not the approach we're going to see from him. And it has to do with just how aggressive the board has been in relation to making new and novel law over the last 4 years. There's a lot to overturn here if Trump wants to make any changes in relation to the current status of labor law, which we fully expect that he does. And I think that that means I get to hand it over to Carl to dive into some of those record-changing and novel things that the GC was doing.
Thanks very much, Beth Ann. So lots of open questions out there, but despite the various uncertainties that Beth Ann just went through, I think one thing is it's pretty safe to assume, and that's that the General Counsel will significantly change the policy and the enforcement priorities of the NLRB. It's, as Beth Ann noted, widely expected that the new General Counsel, or perhaps even the interim General Counsel, will quickly rescind many of the General Counsel memos issued by Abruzzo that provide internal guidance to the various NLRB regions, particularly those with the more novel theories, more pro-employee interpretations of the National Labor Relations Act. As Beth Ann noted, Abruzzo issued over 30 of these GC memos, and we certainly don't have time to get into each of them. But the 2 that are almost certainly on the chopping blocks are GC memos 2104 and 2304, outlining various policy priorities that the NLRB under the Biden administration has pursued. By way of example, these memos are comprehensive, but some of the key ones, some of the key priorities include pursuing challenges to employee handbook policies on confidentiality, employee conduct, social media, professionalism, among many other workplace rules. Pursuing challenges to confidentiality and non-disparagement provisions, and employee separation agreements and employment agreements and other types of employee contracts. Pushing to expand the interpretation of what constitutes protected activity to cover more conduct, including, for example, what's considered a complaint brought by a single employee for the mutual aid of others. Also pursuing lowering the General Counsel's burden of proof, prima facie burden in unfair labor practice cases. For example, by seeking to de-emphasize evidence on causation. Pursuing the standard that would make it more difficult to classify workers as independent contractors rather than employees, thereby expanding the jurisdiction of the NLRB to more workers. Expanding a union's right to access employer property, both physically and digitally, increasing the circumstances under which an employer has a duty to bargain with the union, recognize the union, for example, requiring employers to bargain over policy that arguably fall within the scope of existing collective bargaining agreement provisions, and broadening the remedies available in NLRB proceedings. Again, among other topics covered by these wide-ranging memos. Next slide, please. One of the areas that the General Counsel has been particularly active and is passed in GC memos 2106, 2107, and 2404, which again are likely to be promptly rescinded. These memos expanded the remedies sought by the NLRB in unfair labor practice proceedings, including broad consequential damages. For example, in termination was to go beyond the traditional back pay remedy. And these consequential damages covered expenses incurred by an employee as a result of termination for child care, health care, moving expenses, loans for living expenses, late fees for rent, and so forth. That are quite wide ranging. These memos also instructed NLRB regions to seek full remedies in settlement negotiations to include not only full 100% back pay as well as benefits lost, but also front pay for future wages that the employee would have earned had they not been terminated, along with the array of possible consequential damages. So it's widely expected that the incoming General Counsel will roll back these new remedies detailed in Abruzzo's memos in favor of the more traditional damages and relief pursued by the NLRB under the first Trump administration and prior administrations as well. Next slide, please. Another set of Abruzzo's GC memos that have garnered quite a bit of attention and that are likely to be rescinded are the GC memos 2308 and 2501. These set out guidance to NLRB regions under which a majority of employee non-compete and stay or pay agreements like tuition reimbursement or training reimbursement agreements would be deemed unenforceable and in violation of the NLRA. And it went even further and advocated for a broad make-whole remedy in the event an employer maintained or even just offered a non-compete agreement to an employee. Under these memos, an employer could be on the hook for a wide variety of damages, including lost wages and consequential damages related to an employee having to find a new job, for example, that complied with the non-compete, or a difference in wages if the employee accepted a lower paying job because of the non-compete, legal fees for enforcing or challenging rather the non-compete in court, as well as other types of broad consequential damages, which were unprecedented. And so we expect that the new General Counsel will rescind these aggressive policies, these aggressive positions on non-competes and stay or pay agreements and the remedies available in NLRB proceedings for those. And we'll take a more lenient position towards the enforceability of non-competition and stay or pay agreements under the NLRA. All right, next slide, please. So another area where I think we can expect significant change in policy and enforcement priorities is with respect to joint employer cases. Under the Biden administration, the NLRB issued a final rule seeking to expand the joint employer standard to find a joint employment relationship in more circumstances, including instances where there was more tangential, more indirect control by one company over the workers or the employees of another company. That rule was vacated in March of last year by a Texas federal district court before it ever took effect. And while the NLRB originally appealed that decision, it has since withdrawn that appeal. I think it's likely that the new general counsel will abandon all further efforts to expand the joint employer standard, both via rulemaking or case adjudication, and stick to the rule in effect now, which was, after all, implemented under President Trump's first administration. Next slide, please. So besides rescinding the Abruzzo memos and announcing new policy initiatives and priorities, I think we can also expect a significant change in the NLRB strategy for enforcement of existing NLRB law. I think there's going to be less of an emphasis on enforcement action in general, particularly, I think, with respect to NLRB rules and standards issued under the Biden administration. That said, I think we can reasonably expect that the backlog of unfair labor practice cases to continue, at least in the immediate future, especially if, as Beth Ann outlined, there's going to be cuts to NLRB budget or staff. The new general counsel may also exercise their discretion to strategically withdraw certain unfair labor practices complaints, certain appeals that have been filed under the Biden administration on key issues like some of the topics that we're covering today. We'll most likely get a good idea of the changes in the enforcement priorities when the new general counsel issues their own GC memos, which is expected, outlining their position on key issues and instructing regions to submit certain types of cases to the NLRB division vice to evaluate whether the general counsel may want to pursue enforcement action to overturn, for example, certain precedents. Historically, these advice memos have been issued within a year of a new general counsel appointment, but it's possible that the incoming general counsel may want to move much quicker than that, given the scope of the Biden era precedents that they may potentially be to seek overturn. And so with that, I'm going to go ahead and pass it over to Allison to discuss the Speedy election.
Thank you, Carl. So we're going to talk about speedy elections for a little bit. You've probably heard this referred to as a speedy election or a quickie election, or in some cases, even an ambush election. If you have whiplash due to kind of the ever-changing landscape of this rule, I can understand why. And we're going to get through kind of the history of it in a little bit, but just to give you some context of where these speedy elections fit within the unionization context. So when a union thinks that it has enough support, it can file a petition to represent the bargaining unit or the group of employees it thinks are covered by its jurisdiction. Once it files this petition and requests a hearing, it triggers certain actions by the union and the employer. And the potential actions and the order in which they can occur was largely governed by the timeline. This basically the period of time between the filing of that petition and when the election actually happened. In the past 10 years, this timeline has expanded and contracted along with the rules that have been promulgated by the NLRB. And we're going to go through that in a kind of a brief history of the recent changes in this. So as you can imagine, this back and forth had largely aligned with the changes in the administrations. So for example, in April 2015, the speedy election rule goes into effect. And what it said was basically employers are no longer going to benefit from a fairly relaxed timeline once a union files a representation petition. Instead, we're going to bump everything up so that the election occurs shortly after the petition is filed. And so what did it do? It created about a 3-week timeline between the petition and the actual election for any of the campaigning that was going to happen. And why was this a problem? Really, it's because employers use that time, the time between the petition and the election, to conduct their campaigns, which is perfectly legal thing to do once you get notification that a union wants to come in and represent your employees. These campaigns are an opportunity for employers to educate workers on what a union is, what it'll mean to be represented by a union, any of kind of the factual underpinnings of union representation. But it wasn't just a benefit to the employers. Employees also used that time to do their research and consider whether a union was really the right thing for them, what the promises were that the union was going to make, whether that fit into their kind of perception of where they wanted their career to be, and things like that, right? So this kind of expedited timeline really curtailed employers' ability to conduct their campaigns and employees' ability to make an educated decision on whether or not they wanted to join the union. Fast forward to April 2020. We're in a new administration, and the NLRB walks back some of this rush, right? They say, we are actually no longer going to stick to this expedited timeline. And instead, they created a scheme where there was about a 23-day minimum period between the petition and the election, which really kind of vastly changed the speed with which all of these things occurred. The idea here, at least as the NLRB articulated it, was to balance the priorities of the union with the priorities of the employer. So things that this new rule, the April 2020 rule, lengthened was the deadline to post and distribute the notice of a petition for election, which used to be 2 days in the under the 2015 regime, and then was expanded to 5 days under the 2020 regime. It expanded the deadline for pre-election hearings on certain topics and issues, which used to be 8 calendar days under the prior kind of 2015 rule, and then changed to 14 business days from the service of the notice of hearing under this 2020 rule. It lengthened the amount of time that the parties themselves had the ability to submit statements of position with respect to the bargaining unit or any of the other issues that they wanted to present pre-election. And that's typically done by both sides. And it also expanded the deadline to file a voter list by the employer, which basically gave the union and the NLRB, put them on notice of which employees would be eligible for the bargaining unit and which employees would be eligible to vote. The other things that this April 2020 rule did is that it permitted the parties to file post-hearing briefs, which had historically actually been only done upon request. It also prohibited regional directors from scheduling the election less than 20 business days from the date of the direction of the election. Meaning it meant that there was kind of a universal rule that these elections had to occur at least 21 business days, if not longer, from the date of the direction of the election. It also changed, and this is really important, the order in which certain issues, such as questions of representation or the scope of the bargaining unit, were resolved. What it said was basically all of that now comes before the election is scheduled, rather than after the election. Under April 2015 rule, all of those issues that came up in almost every single election, at least that I had participated in, were mandated to occur after the election, and basically only if they were going to be dispositive of the results, right? So if those issues would then impact the results, then you were heard on them. Under this April 2020 rule, it went back to this idea that you could bring these up pre-election, but that also, again, remember, lengthened the timeline between the petition and when the election could be heard. Next slide, please. Okay. So in December 2023, again, under a different administration, we go back to basically the pre-2015 the pre-2020 rule. What it says is, again, elections can be held less than 3 weeks after the petition was filed. It also permitted electronic petition filing, which basically meant this was a more streamlined and faster approach to actually getting closer to the election. It required employers to provide the email addresses and phone numbers for faster communications with the voters. And it deferred these non-essential issues. These are the issues that I spoke about before, with scope of representation and things like that, until after the election. And that allowed the timeline between the petition and the election to be condensed, because you weren't waiting to have a hearing and then post-hearing briefs and then a decision made on these before the election could even occur. It also eliminated any sort of pre-election hearings on issues beyond things like whether or not supervisors should be in the union or certain positions should be in the union. But if you think about it, what this also did was it meant that employees also didn't get answers to these questions until after the election occurred and after they had to vote. Basically, under the present rule, the advantage went back to the union, coupled with the Cemex decision that Taylor is going to talk about in a little bit. The union really had the upper hand in the election process after the promulgation of this December 2023 rule. Next slide, please. Okay. So the new board and the new GC appointed by the Trump administration is expected to reverse Biden's quick election rules. Remember, under Trump's first administration, that's exactly what happened with the Obama era quick election rules. And so what does this mean? It'll mean that there will be more pre-election resolutions, meaning resolutions on issues prior to the election, rather than having to wait until after the election and only address these issues if they would change the results of the election itself. It paves the way for an employer to challenge the validity of the petition or the scope of the bargaining unit, again, prior to the election. It allows the employer to launch a more robust campaign because they don't have to get the petition for election, figure out what all their issues are that they're going to challenge with respect to the election, and also educate the employees on what the facts are surrounding union representation. And it permits employees to educate themselves on the issue. So what does that mean for you? We obviously can't predict when and if this is going to happen, although, like Beth Ann said, if I was a betting woman, I would expect that this would happen fairly quickly. What you might want to do to prepare for this is assess your workforce and evaluate whether your workforce is ripe for organizing. We're seeing an expansion of organization in mom and pop shops, in more industries than we've ever seen before, and more job titles than we're ever seeing before. So see whether or not you might be a target of it. And I know that I said, okay, well, this will expand the timeline. And so you might be thinking, well, why do I have to do this if I have more time? But the truth is that even if we expand the timeline, you still might be looking at only a month, for example, between the petition and the hearing. And so other things that you can do are kind of preempt the education issue by starting to educate your employees on union matters at this time. Do it in a legal way. But do it in a way that will cut out some of the need for a kind of a quick effort once you get a petition for election, and figure out what your arguments are going to be as to who you want to be excluded from the bargaining unit in preparation for the filing of a petition of an election. I'm going to turn it over now to Taylor.
Before we turn it over to Taylor, as the moderator, I'm happy to report to those of you that are eligible for continuing legal education credits that we have a code for today's presentation. The code is Shakeup, one word, SHAKEUP 2025 to receive CLE credits.
Thanks, Mike, and thank you, Allison. So like Allison mentioned, Allison's topic of speedy elections and this next topic of the Cemex decision couples really nicely. So just a quick background. So the Cemex Construction Materials Pacific board decision was decided in August of 2023. It is one, if not the most consequential decisions to come out of the last 4 years, and that it upended nearly 50 years of labor law precedent respecting representation procedures and bargaining orders. While you probably have heard of this decision, it does bear further discussion today due to the implications, the effects of those implications that we've seen so far, and what the future looks like respecting this decision. So in 2019, the International Brotherhood of Teamsters campaigned to organize a bargaining unit of cement truck drivers and driver trainers. The Cemex employees, located across 24 facilities throughout Southern California and Nevada, eventually voted against the representation by the Teamsters by only a thin margin. The union filed unfair labor practice charges, alleging that the employer had engaged in extensive, unlawful, and coercive conduct before, during, and after the election. Some of those complaints were that Cemex threatened employees who appeared to favor union representation. They engaged in surveillance of those employees. They restricted employees from communicating with the union representatives. Cemex hired security guards to intimidate employees, and more. A NLRB administrative law judge found that the employer violated Section 8A1 of the National Labor Relations Act more than 24 times. The ALJ recommended setting aside the election and ordering the employer to provide access to special remedies before a rerun election. Now, on review, the board did affirm the ALJ's ruling and impose its recommended remedies. However, the board fundamentally rewrote the rules by which a union can establish exclusive representation of bargaining unit employees and put greater pressure on employers when they're faced with union organizing. Now, as seen on this slide, the first consequential outcome of the Cemex decision is the changes to the voluntary recognition procedures. The board upended more than 50 years of legal precedent by overruling the Linden Lumber's Supreme Court decision by establishing a new representation procedure. Now, just to reflect, the Linden Lumber's decision was where an employer, when represented with union authorization cards, reportedly signed by a majority of employees, the employer could reject the cards and insist on a board-conducted election without any reason to do so. Essentially, the employer could just flat out ignore the voluntary demand and wait for the union to go to the NLRB. The onus was on the union, not the employer. But under Cemex, the board rewrote the framework. Now, an employer will have violated the act by refusing to recognize a union once a demand for recognition has been made, unless the employer promptly files a RM petition, which tests the union's majority status or the appropriateness of the unit, or agrees to recognize the union that made the demand. Now, based on the Cemex decision and the guidance that was promptly prepared and posted by the general counsel, the prompt filing of the RM petition is 2 weeks from the date that the employer receives the voluntary recognition demand. The Cemex decision left and has currently left employers with 3 options. The first, they could agree to recognize and bargain with the union that the union sought to or is seeking to recognize and represent. Next, the employer could file a RM petition within 2 weeks of receiving that demand for voluntary recognition. The RM petition challenges the unit that's being sought by the union, rather than the employer setting forth that there is no appropriate union. or there is some, permutations to the unit that the union put forward. And the third option is that the employer could do nothing, and then instead they could defend a refusal to bargain unfair labor practice. So the employer can challenge the ULP charge that will be filed by the union, and then they can explain its basis for refusing to recognize. This is definitely within the past 2 years, this would be a more riskier option, considering what happens next in terms of the Cemex decision. Now, the employers have to make this decision all within the span of 2 weeks, meaning they have to gather the necessary information, confer with everyone involved in the decision-making process, see and decide who really could be in a unit, whether a unit is appropriate, whether the group that's been assembled by the union is appropriate. And that's a big decision, especially for most of our larger employers and smaller employers alike. This specific conduct or a decision that came through from Cemex left open some open-ended questions, especially because it changed the procedure that's been around in existence for 50 years. So the General Counsel of Abruzzo issued a GC Memorandum 2401. GC memos are intended to provide guidance to the regional offices on how they should interpret and enforce certain board decisions. These GC memos also assist the General Counsel in setting forth their own agenda. This particular memo, GC 2401, clarified what constitutes a demand for recognition by stating that an informal oral demand for recognition made to anyone acting as an agent of the employer will satisfy this requirement and trigger the 2-week timeline. And that 2 weeks is when the employer has to decide to recognize the union, file an RM petition, or do nothing and defend an unfair labor practice charge. The GC memo also clarified that even if a RM petition is filed by the employer, it's the employer's obligation, not the union. And the employer bears the burden of demonstrating that the union's unit originally sought is inappropriate. Some effects that we've seen so far regarding this aspect of the decision is that there's obviously been an increase in union organization efforts and voluntary demands for recognition. Unions are asking to be voluntarily recognized by their employers without maintaining a sufficient number of union authorization cards. Under the GC memo, a union has no obligation to share the evidence of majority support, nor will such a request toll the 2-week deadline for filing an RM petition. Unions are also asking the employers to voluntarily recognize larger units of incongruent groups of individuals, because they're anticipating that employers don't have the time, resources, or stomach in some cases to file an RM petition and go through a pre-election hearing. Even if an employer does elect to file a RM petition, they run a new risk of receiving a bargaining order prior to an election due to potential unlawful conduct during the quote critical period before an election. Gabby, could you go to the next slide, please? Now, the next outcome of the Cemex decision is a Cemex bargaining order. Prior to this decision, under the standard established in the Gissel Packing Co. Supreme Court decision in 1969, the board could implement a bargaining order without an election where a union has achieved majority support and an employer engages in unfair labor practices, which have, quote, the tendency to undermine majority strength and impede the election process. Now, under the Cemex bargaining order, the board will focus on the employer's conduct prior to the filing of an election petition and in the period immediately preceding the election. And the board is empowered to issue bargaining orders based on the employer's conduct prior to the election. As NLRB General Counsel Abruzzo clarified in a memorandum following the Cemex decision, a Cemex order differs from a Gissel order. The Gissel order is issued when the Cemex order My mistake. The dismissal order is issued when the election atmosphere has been tainted by an employer to a point where a fair rerun election is unlikely. The effects of the Cemex bargaining order so far, I mean, there's been countless questions that have arose from employers, unions, and individuals alike. Particularly regarding the Cemex bargaining order, what constitutes unlawful conduct that would trigger this type of order? And not only could be surveillance or obviously terminations of individuals who support the union, but could also be as simple as serving free stakes branded with the words "vote no" prior to an election. Gabby, could you go to the next slide, please? To no surprise, an appeal was quickly filed. The Ninth Circuit is currently addressing this appeal. On October 21st, 2024, panel heard oral arguments. One of the fundamental issues presented to the Ninth Circuit was, can the board even engage in this kind of rule and procedure making through the adjudication process, rather than through a notice and comment period? The panel of judges during the oral argument indicated through their questioning that they are likely to rule consistent with their political ideologies. Judge Clifton, for example, nominated by President George W. Bush, seemed to view the portion of the Cemex holding essentially requiring employers to file RM petitions if presented with a request for voluntary recognition with skepticism, stating that it was clearly not the law for the board to issue bargaining orders after a failure to respond to a demand for recognition. Judge Clifton also hinted that the board was arbitrarily exercising regulatory power and creating a new standard, which should have been done through rulemaking, not through the adjudication process. However, in the oral arguments, the NLRB attorney maintained that the case presented a need for a change in the law to better remedy pre-election unfair labor practices, and that the board was permissibly creating and applying alternative rationale for a bargaining order, essentially issuing two separate bargaining orders. Now, Judge Chung and Judge Sanchez, both nominated by President Biden, their questions seem to indicate that they are agreeing with the NLRB and that the new Cemex standard could be issued through adjudication rather than through rulemaking. The Ninth Circuit tends to issue decisions anywhere from 3 months to 1 year after oral arguments, so a decision is likely to drop in any time or within the next few months. The party on the losing end of the appeal will likely file a petition for writ certiorari with the U.S. Supreme Court. Now, at the administrative level, and jumping off of this earlier discussion from Beth Ann, we are likely to receive, or GC Russo is likely to no longer be the GC, and a Trump-appointed general counsel is likely shortcoming. Now, the GC shapes the agenda of the NLRB and instructs the regions on its positions with certain cases that the regions should file through their GC memos. The Trump-appointed GC will likely quickly rescind the GC 2401 memo, probably fairly quickly. Also, like Beth Ann mentioned earlier, former board member Kaplan, now board chair Kaplan, as of literally yesterday, is the board chair, and President Trump has the opportunity to appoint 2 new board members. Now, notably, board chair Kaplan was the lonely dissenter in the Cemex decision. He disagreed with his colleagues in their creation of a Cemex bargaining order, and also in their overruling of Linden Lumbers and the setting forth of a representation procedure. So if should President Trump fill those 2 board positions with Republican board members, board chair Kaplan could then have other members on the board to support his dissenting opinions and overturn the Cemex decision. The timing obviously depends on how quickly and if President Trump puts forth to Republican board members. And with that, I'm going to turn the slides back over to Mike.
Thank you to all the panelists. I have a couple of questions here. And the first one I'd like to, since we were just talking about the Cemex case and its import, I'll direct this to Taylor, although other panelists can jump in. It would seem to me as an employer that at this point, if you were confronted with a demand for recognition, given the uncertainty of the status of that decision, you would figure out a strategy to not voluntarily recognize a union, figure out the timing on the potential decision from the Ninth Circuit and changes at the board level, either through the chair or a new general counsel or some combination. So the question presented is, wouldn't it be prudent, in that we've seen a 23% uptick in organizing across the country, to refuse an oral or written demand for voluntary recognition? And how soon should you do that after receipt of the demand?
Thanks, Mike, for the question. Completely agree with the current, direction where we're heading, and employers who are hearing ruminations of potential union organizing should ascertain the potential unit in the first instance that the union organizers are seeking to represent. Thereafter, once they receive a demand for recognition, you could wait the 2 weeks. You could respond immediately. It's up to the employer's preference and their desire to challenge and litigate an unfair labor practice charge. But given the direction we're heading in, it's a better option than it was, frankly, 2 years ago.
Thank you. The next question, I guess this is directed at Beth Ann. In that President Trump received approximately 78 million votes, it is clear that there's some support from various portions of the labor or labor industries or industries that have labor. And I think from your comments, you indicated that we wouldn't see a complete dismantling of the NLRB and the NLRA because of labor support and because of the potential constitutional administrative law challenges to that dismantling. Will there be, in your opinion, litigation that continues on that front, that is challenging the constitutionality of the board or its composition and its ability to make rules that would affect or help employers as opposed to unions, given the direction of the current administration?
I can say confidently, I fully expect our courts will be very busy on a number of fronts. This is one of many topics where we have a divided country in relation to a belief of what is right and what should be occurring. And whoever isn't seeing what they want and expect from the board is going to turn to the courts to see if they can get what they feel that they need there. So I think that's at the end of the day, a pretty easy question to answer. Yeah, I think our courts are going to be very busy, and including in relation to challenges, some of which I think will continue to look similar to what we've been saying, those constitutional challenges to the approach of the board. But we might see less of those and more from the union side of things if they feel like things aren't being handled appropriately. A good example, I mean, this is a tangled web, right? A really good example is, will we continue to see challenges on the constitutionality based on the remedies that the board is saying that it can impose in the event that there's a finding that there has been an unfair labor practice charge? Well, not if they take those remedies away. But the idea that we won't see anything in the courts and there won't be challenges, I think that that would be a stretch of the imagination. We're going to see a lot of litigation around the board and what it should and should not be able to do and what that looks like.
Thank you. And just so the audience knows, the National Labor Relations Act empowers a sitting president to make appointments to the NLRB's board, but it does not compel the president to do so. And that, in theory, conflicts with some case law that would say if the NLRB or is supposed to act under the NLRA to enforce statutory rights and they are not being enforced, the courts, according to the case law, can step in if those statutory rights are being sacrificed or obliterated. So we're in this interesting time where if the full composition of the board is not in place, and if of the 3 sitting, one of the terms expires and then we're down to 2 when it can act. The NLRB could not act with only 2 members. There may be, to Beth Ann's point, a greater likelihood of litigation to resolve and decide some of these issues. We have another question. I wanted to direct this at Carl. You mentioned in your presentation that there were priorities under the prior administration and the NLRB, priorities to address the area of non-competes, which we see on the employment law front as being something addressed by many states. And what can we anticipate in the NLRA world as regards non-competes moving forward in their enforceability?
Thanks, Mike, for that question. So I fully expect that the recent GC memos will be rescinded, and I would say, more novel theories suggesting that the vast majority of non-competes are unenforceable to be completely changed under the new administration. I suspect the administration will take a more lenient approach with the enforceability of non-competes, and it's fairly consistent with the approach taken under the first Trump administration. And I think the approach taken by a majority, though definitely not all courts, as state courts. I think I'm not sure we'll see a lot of enforcement action on this front. I think besides rescinding the GC memos, I don't see a lot of rulemaking or case adjudication on this, except maybe complaints have already been filed under the Russo's administration.
There was a follow-up question on that point. If you're an employer faced with a currently pending investigation, what practical advice could you give to that employer in terms of all the tumult that we see in the NLRA, NLRB world today? What should an employer do if an investigation started last week?
Yeah, certainly take an aggressive approach, maybe consider remedies and action that would have been not been prudent under the prior administration. Consider arguing for an expansion of or an overturn of the current policy and see and get some traction on that front. And certainly, I wouldn't. I would definitely take
You honed in on an important point that I want to emphasize to the employers on the phone. If you're going through the process of preparing a position statement or evidence in support of why there was not a violation of the NLRA, I think what Carl is pointing out is exactly correct. Raise every defense and every challenge that you can to the issues presented, because in this brave new world, we will not know what will be enforceable or what will be standing, if you will, a few months from now or a year from now. And to the extent you've preserved those defenses or arguments in your initial submissions, the better position you'll be in.
Mike, if I may, I just wanted to add something to Carl's response to the non-compete question. I definitely agree with Carl, and I think that you're going to just see the NLRB kind of take a step back from regulating about non-competes. But what that does is actually it makes it right for states to then step in and on a state-by-state level have them legislate, which some states have already done, have them legislate as to any sort of either restrictions on non-competes, or you've seen some states try to just eliminate them altogether. And so what we expect to be the position of the new NLRB under the Trump administration, what that really just means is that you would, as an employer, you shift your focus away from determining whether or not there is kind of a federal landscape on it, and instead shift your focus to what is your state saying about it, including once these laws are promulgated, whether or not there's any then subsequent court action that chips away at what the state legislation says.
Thank you, Allison. And as happens often in these moments, Allison jumped in and gave us some great advice, and the next question's for her. So whether a speedy election or a non-speedy or quickie election framework applies, you started to give some practical advice to employers, sort of what to do under either framework. So if the foundational premise is the NLRB and the NLRB in the next 2 years at least will exist, what should employers be doing if there's going to continue to be an uptick in union organizing across the country? And that remains to be seen. What should employers do immediately to determine if they're susceptible to organizing under either the speedy or non-speedy election framework timeline?
Yeah, thanks for the question. So I did address some of it, which is, doing an assessment of your workforce to see whether or not you are kind of exposed to union organization. Like I said, we're seeing these efforts in smaller and smaller venues now. And also within job titles and classifications that weren't kind of historically unionized workforces. So that's something that you want to take a look at. But the other thing that kind of shows you whether or not you have exposure is probably a revamp or at least an evaluation of what your workplace policies are, right? A lot of times these unionization efforts are the result of unhappy workers and or these successful unionization efforts, I guess I should say, are the result of unhappy workers in the workplace. And a lot of that stems from the existence and application of workplace policies. And so to the extent that you can evaluate whether or not there's things that could be either more favorable to employees or things that you are perhaps applying inconsistently that you can then apply across the board. Those are ways in which you can start to contribute to the overall positive morale of your employee workforce, and also maybe decrease your exposure or decrease the potential success of a unionization position.
Thank you. So I want to remind the audience that there was CLE credit available for this presentation, and I'll give you the code again. It is Shakeup, one word, SHAKEUP 2025. Gabby, would you please put up the slide respecting the February webinar? This concludes the shakeup at the NLRB, what employers can expect during President Trump's second administration. There is another webinar on labor-related topics coming to a workplace near you. That is your workplace. During February, I'm sure some of you have seen some materials about that already. And I'd be remiss if I don't tell you that there was a question also as to whether or not we'd share the PowerPoint, which we will, with participants. So we've exhausted the hour. We thank you for your time, and we hope to see you soon on a future webinar. Thank you all.